good morning, everyone. My name is Romy Jurado. I'm an attorney here in South Florida. The name of our law firm is called Jurado and Associates. In our firm, we do a couple of different things. We do business law, real estate, immigration, litigation, copyrights, trademarks, state planning, probate, all over the state of Florida. Trademark is actually federal law, so we do it all over the United States. In today's presentation, I'm going to focus on trademarks, copyrights, and everything regarding intellectual property protection. If you have any questions, please feel free to put it in the Q&A. You could also put it in the chat. I'm hoping to record this so I can send everybody a recording probably next week. And again, thank you so much for joining me today. I wish everybody a wonderful week. So let's get started. Okay, everybody should be able to see my screen now. Again, my name is Romy Jurado. I'm an attorney here in Florida. And you can see on the screen the different areas that we cover. But today's presentation is about trademarks. So let's talk about it. It's called trademark prosecution, and it sounds a little scary, but it really isn't. It's a fairly straightforward process if done correctly. If you make a mistake at the beginning, it's going to come and bite you at the end. So this is a little outline of the different things we're going to cover. I like to make my presentations quickly to the point. So any questions, please feel free to ask. We're going to talk about the types of marks, the benefits of trademark registration, how to select the mark, the requirements for registration, dealing with the trademark examiners, and of course, registration with U.S. Customs. For those of you that are selling goods, that are bringing stuff from other countries, it is so important not just to have your trademark, but also to register with U.S. Customs. So give me just 1 second. All right, so types of marks. So what is a trademark? What do we mean when we talk about trademark? So what can you trademark? You can trademark words, you can trademark names, you can trademark phrases, you can trademark symbols, and you can trademark designs. You could also copyright designs, but you can trademark words, any word that you use together to reflect your business. Any name that you use to reflect your business or product or service. Phrases that you use, so it's not just the name of your business, is if you use a catchy phrase as it relates to your product or your service, you can trademark that. Symbols, any symbol that you've designed, any designs, and music too, sounds, you could also trademark that. So you can do different things that will show the type of business that you have. It's anything that is used to identify and distinguish goods from those manufactured by others, right? So it's used to identify and distinguish goods from those manufactured by others, to indicate that source of goods, even if that source is unknown. So if you trademark something, you're letting the world know, this is my good, this is my services, and it came from this, from us, from your company, from your entity that you have formed. We also have service marks, right? Which is still a trademark. Service marks are the same thing as trademarks, except that they identify distinguished services instead of products. Here you have some examples. AA for airline services, right? McDonald's for restaurant service. Now, you could also trademark McDonald's to sell hamburgers itself with the logo of McDonald's, but you could also trademark McDonald's to provide the service, in this case, a restaurant service. Or like what I do, right? I'm an attorney, I provide legal services. So if I wanted to trademark a catchy phrase with it, I could. And you can do that, of course, to protect your services or products. So what protection is available? The rightful owner of a trademark or service mark, just a trademark, can prohibit others from using the same mark or another mark, which is so similar in sound, meaning, or appearance that it would be likely to lead to confusion among customers regarding the source of the products or services in connection with which the mark is used. So what does that mean? If you have a registered trademark in a particular service or product, you can stop everybody in the United States, if it's a federal trademark, from using that particular trademark as it relates to that service or product. Okay, so it is a very powerful tool. So how do you use this tool? Well, let's say you already have the registered trademark and you see, and you have to do this, you have to protect your mark. You see a restaurant using that same name that you protected. You have to let us know so we can send them a cease and desist notice for them to stop using that trademark. If they don't, now you can sue them and now you can recover attorney's fees and costs. And you're probably going to win because you have a registered trademark. You have to, it's not enough to just get the trademark. You have to prosecute it. Right? Sorry, not prosecute it. You have to continue to guard it. You have to protect it. If you see anybody else using it, we have to send them a cease and desist letter so they stop. And if they don't stop, then we have to sue them. But then again, you're going to recover attorney's fees and costs. And a lot of attorneys, and not all, will take on the representation probably on a contingency basis because your likelihood of winning is very high. Okay. So let's see. I think I have a question. I love questions, so keep them coming. Can you copyright or trademark a book or a movie title? Okay, let's talk about that. So let's say that you put together a fabulous book. Can you copyright it? Absolutely. How do you copyright it? Well, we will ask you for your book and we will send it to the copyright office and they will keep a copy of it and they will give us a copyright on everything that's written on that book so nobody else can use it. Now, within that book, you can have some pictures, you can have some writings, correct? Now, you could also trademark the name of the book. So let's say that you came up with a really nice name that you want to protect as it relates to your book. So now we're going to trademark the name of the book and we're going to copyright the contents of the book. So you're protected all over. Can you trademark a movie title? Absolutely. Same thing applies. We are going to trademark that movie title. Okay, so you can protect it and then you can copyright the movie too, so nobody else can copy it. Absolutely. How much does it cost to register a federal trademark? That's a great question. And I will love to answer it, but I can't do it via video because I don't know when somebody's going to see this, maybe 10 years from now, 5 years from now. So email me and I will absolutely send you pricing. We do have flat fee pricing and we're very competitive. So send me an email and I will send it to you right away. Let me put my contact information on the chat so that everybody has it. So you can find me all over social media with my name, Romy Jurado, all over the place. And my phone number, I'm going to put it right here. It's 921-0976. My email, it's Romy@JuradoLawFirm.com. But in Instagram, Facebook, I'm there with Romy Jurado all over the place, so you can definitely find me there. All right, we have another question. We have an ongoing monthly Zoom event that we call Let's Talk Luxury. Okay, we never register or copyright it. How can we protect the brand so that other real estate agents can use that branding? We will protect that slogan. So that's a slogan as it relates to real estate related services. Now, when we file for protection, we will prove that we have been using that slogan and we can say since when we've been using it. Did we start using this in 2011, 2010, 2012? We will tell the trademark office, this is a slogan we want to protect. We started using it in this date. And here is the proof. I want to see some branding. I want to see stuff as it relates. In this case, I would say with real estate related services. Probably you also want to protect it if it's like a podcast as it relates to communication over the internet services. So it just depends on how many classes. So the way the trademark world works is protected by classes. So we will ask you, tell us everything that you're doing with this slogan, with this name right now. And tell us everything that you're doing with the slogan. No, tell us everything that you plan to do with this slogan or this name in the future. And then we will analyze it and tell you, we think that all these classes apply to this, or we think that you can use these classes now, but maybe these others in the future. We will legally advise you as to what we think your best plan of protection is. So sometimes, for example, I have a lot of restaurant clients. I love to eat, so I love to have them as clients. And they want to protect, of course, in the restaurant class, but then they tell me they also want to make t-shirts and they want to make stuff like that. So then we also want to protect in the t-shirt class. You see, 2 different classes. Or sometimes they tell me, Romy, I also created a podcast regarding my restaurant. So then that's another class. So what I like to do is I like to ask the client for everything they're doing now, what do you plan to do in the future? And then we will develop an intellectual property plan of protection so we could see what we need to trademark now and what we need to trademark in the future. Or you could also protect it now, even though you're not using it. And I'm going to talk about that in a minute. But it also comes down to budget, right? Because the more you trademark, the more it costs. And we're going to talk about that as well. So first of all, when you're thinking about a name of the business, please don't have it be generic because you're not going to get protection, right? You might get some protection. They can put you on a, on a separate registration, which is called a supplemental registry, which affords some protection, but it's not the main registry. The reason why people sometimes go into the supplemental registry is because the trademark that they're trying to protect, the brand, the logo, it's too generic. So if it's too generic or it says what it's selling, then you're going to run into that issue. So what do we like to see as far as trademarks? Well, we want to protect distinctive marks, right? So descriptive marks is what we want to stay away from, such as geographic names, surnames are not inherently distinctive and can only be protected if they can be shown to have attained distinctiveness through use, referred as secondary meaning, okay? So we would have to show that. Arbitrary, fanciful, and suggestive marks are deemed to be inherently distinctive, right? Generic terms are unprotectable and can never function as a trademark. Once a word becomes generic, it's lost for trademark purposes. So let's talk about some examples. So what do I mean when I say arbitrary for the trademark world? Well, I want you to use words that are in common, but bear no relationship to the associated goods. For example, Apple for computers, obviously we know they have a trademark, but can you protect Apple for selling apples? No, but you could potentially protect Rummy's apples. Yes, because now you're giving it a sense of, it's different. It's not just an apple, it's Rummy's apples. So that you could potentially protect. But Apple itself, for apples, you will not, but Apple for computers, you can. Suggestive, right? So you want to suggest some quality or character of the associated goods, but not so explicitly that no imagination is needed to determine the nature of the good. For example, copper tone for sunblock lotion. If you listen to copper tone, it kind of suggests, okay, you're going to have a copper tone. Nice. But it's not telling you we are a sunblock lotion. However, it kind of suggests it. So that's an interesting mark to protect, and you can get protection. Fanciful, right? So this is something composed of coined words together. So for example, Xerox for photocopiers, right? You can protect that. As we know, it's protected. Descriptive, so marks that describe qualities, ingredients, or characteristics of the products or the services with which the marks are used. It's also can work, cannot work, it just depends. So for example, beef and brew for a restaurant. And then we don't want to see generic. Generic is what we want to stay away from. A common group or class name such as beer, shoe, or automobile to which particular product belongs, a generic term can never be a trademark for the identified goods. For example, apple for fruit, you're never going to be able to trademark that because you cannot stop the world, or actually within the United States, from using apple for fruits, right? So what are the benefits of trademark registration? Well, first, to use in the US, the federal registration is not required to establish rights in trademark. Rather, common law rights arise from actual use of a mark, whether or not it is the subject of federal registration. Generally, the first to use a mark in commerce or file an intent to use application with the USPTO has the ultimate right to use and register the mark. Registration is usually not required. However, even if the senior user does not have a registration for its mark, under Section 43A of the Trademark Act, the senior user generally may stop user that has obtained federal registration for its mark. So if somebody was using the mark before you registered, they may be able to fight you. However, registration is recommended because even though registration is not required for trademark protection, it is advisable for a company to obtain registration for its trademarks so that you can get attorney's fees and costs if you need to fight it. So I always recommend my clients to register your mark. Now, the United States Patent and Trademark Office, it's going to do a full search before they give you registration. And if they don't see that nobody else registers using the mark, they're going to give you that registration. And after a couple of years, that registration becomes uncontestable, which is great. So registration, why do we recommend registration? Because it confirms important benefits to the trademark owner. For example, possibility of treble damages for infringement. So you send somebody a cease and desist letter, they decided not to stop using it. So now you can sue them and you may be able to recover 3 times the damages. Also, there is a presumption once you have a registered trademark that you are the owner of the mark. Also, geographic coverage, right? If you have a registered trademark, you can stop anybody using your trademark anywhere in the United States, even though you never set foot in that location. So if you have a federal registered trademark and somebody's using your brand that you find out about in Wyoming, you can send them a cease and desist letter, and if they don't stop, you can sue them and recover possibly treble damages and attorney's fees and costs. Also, incontestability. After 5 years upon filing an affidavit, of continuous use, you may be able to get incontestability, which is great. So that is something to look forward to. Selection of marks, let's keep on talking about that. So what does the R symbol mean? The R with the little circle means that the trademark owner is giving notice about a particular mark that has been registered with the United States Patent and Trademark Office. You cannot use the R until your registration has been granted. Not that you filed for it to register, but that it actually has been granted, right? If the USPTO, the United States Patent and Trademark Office, sees a little R, okay, in your product and you don't have a registration or it's pending, they may punish you for that because it's an improper use and you're not going to be able to get a registration. So do not use the little R with the little circle until your mark has been registered. What can you use? You can use the TM symbol. The TM symbol is used by trademark owners before they obtain a federal registration for their trademark. Okay, you are telling the world you have common law rights for that trademark. The use of the TM, while not required by trademark laws, can serve many useful purposes for trademark owners, such as telling somebody else you have, common law rights. My advice, put the TM there, file for registration. Once you get your registration, absolutely put the little R in all your products or your website if you're providing services. So what else? What else do we want to talk about? What happens when somebody says you infringe on their trademark? What is it that happens? So if you are on the other end, right, receiving a cease and desist letter, or if we receive something called a notice of action, right, an office action, that means we have to tell the United States Patent and Trademark Office why should they register a trademark when they found something that conflicts with another mark. Well, the way we put this together, the way we make legal arguments is we rely on something called the DuPont factors. So there was a case, right, that set out these 13 factors that the United States Patent and Trademark Office attorneys need to weigh in order to determine whether a mark is very similar to another and likely to be confused by another. So if we ever get an office action, this is what we're going to use to fight trademark. So one, they look at the similarity or dissimilarity of the marks in their entireties as to appearance, sound, connotation, and commercial impression. Two, they look at the similarity or dissimilarity of the goods for which the marks are used. Three, they will look at the similarity of the channels of trade of the goods for which the marks are used. Let me give you a real life example. We filed for a trademark for a client that was selling wedding dresses. And the United States Patent and Trademark Office gave us an office action and said, no, we cannot register because your mark is very similar to this other one. And we came back to them and we said, no, hold on a second, because we are in different channels of trade. The other brand is selling their products, in very, let's say, economic stores, stores that are very open to the public, very economic. Whereas our client is selling their product in high-end luxury stores. So it is, very unlikely that the consumer will confuse them because they're different channels of trade. The consumer that goes here, the likelihood of them going to this really high-end, super expensive store is, lower. So we don't think they should be stopped for granting the trademark just because of that. That is an argument that we made. We also said the sophistication of the purchaser. You could also argue that impulse buying versus careful, sophisticated purchasing. We said that when you go to these high-end stores, you're not going to do some impulse buying because you want to choose the right wedding dress, especially for your wedding, right? Who doesn't want a nice wedding dress? So we also argued that, I think, back then, and we were able to succeed. So you can make these arguments. So also they're going to look at the fame of the senior mark, right? The number and nature of similar marks in use or similar goods, the nature and extent of any actual confusion, the length of time under which there has been concurrent use without evidence of actual confusion, the variety of goods on which the mark is used, the market interface between junior and senior users, the extent to which the applicant has a right to exclude others from use of the mark on goods, the strength of the mark, the extent of potential confusion, and any other established fact probative of the effect of use. So we use these DuPont factors to argue when we get office actions and to say that they should register our client marks. So that is what they look at. Okay. Clearance searches. So whenever we're hired to file a trademark, right, we can just file your trademark, no problem. I recommend to do a clearance search, right? You want to make sure that, or at least know what is your likelihood of registration before filing, because getting a trademark from the moment that you file to the moment that you get that certificate can take about a year, okay? So you won't know. However, if we do a clearance search, we are taking measures to avoid, infringing on other marks and future problems. And we can do that. We can register, we can search the federal applications, we can search registrations. We could also register in every state, because every state has their own trademark office. So through a full trademark search, we search registered marks, unregistered marks, in the different states at the federal level, and then we actually issue a legal opinion on what we think the likelihood of registration is. Of course, nothing is guaranteed. I don't know what the United States Patent and Trademark Attorney will come back at, because they have access to a lot more things that we may not even know. But at least it gives you an idea, and then we can make a decision from there. So I absolutely recommend it. Okay, I see somebody raised their hand. So if you could put the question here in the Q&A or the chat, I'll gladly answer it. Requirements for registration, right? So in order for you to register, you actually have to be using the mark. However, we can start the process with something called intent to use. So there's actually two ways to start a registration process. One is we are already using the mark in commerce and we submit proof that we're using it. And the other one is we plan to use the mark. If you plan to use any mark, I recommend filing intent to use, because that gets the ball rolling. The attorney is going to be assigned at the United States Patent and Trademark Office. They're going to start doing their searches. They're going to issue a notice of allowance, which is going to tell us, okay, great, they don't think there's any conflicting marks, and the process keeps on rolling. However, you will not get your certificate until we prove, we allege use. We show we're actually using it now, but it does get the ball rolling. So assuming a mark is capable of registration, the mark ultimately must be used in commerce before the United States Patent and Trademark Office will issue a registration. Use in commerce is defined as all commerce which may be lawfully registered regulated by Congress. This typically includes commerce between states and commerce between the United States and a foreign country. Sales of goods across state borders or into the United States from a foreign country will constitute use in commerce, okay? And I'm also going to talk to you about the principal registry and supplemental registry. The principal registry is where everybody wants to be, right? The supplemental registry, it's also reflected in the United States Patent and Trademark Office website, but it means that your mark was not, let's say, as distinctive, right? Now you have to show them that you're distinctive in a couple of years, so that then you can move to the principal registry. So we always try to be in the principal registry, but if you have a mark that you're like, Romy, I really, really want to protect this. I know that it kind of says what it does, but I still want to protect it. Then we may end up in the supplemental registry, and maybe after a couple of years, we can show that you're distinctive, that you've attained, that a lot of people know about your brand, even though it's kind of descriptive, and we may be able to move you to the principal registry. Okay, let's see. I think I have a question here. Does the clearance search check against other pending trademarks or only registered ones? What happens if your pending trademark is going against another pending trademarks? Yes, in the clearance search that we do, the full search, we will check against pending marks, because we want to make sure that if somebody has a pending mark, remember they filed before you, the United States Patent and Trademark Office, it's not going to issue your trademark because they see that a pending mark, but what they're going to do is basically put your trademark on hold until they determine whether this trademark is going forward. And then once that goes forward, yours is not going to go through. So when we do a full trademark search, we do check about pending marks. So that's a great question. Let's keep talking about requirements for registration. Again, as I mentioned before, there are two main paths to registering in the principal registry. One is use-based application. Basically, a person or company who already has used the mark in commerce may file an application based on this. They're using it. The other one is intent to use, right? So a person or company who has a bona fide intention, you can't just go around saying, I'm going to use this, I'm going to use this. You have to actually intend to use it. Then you may file an application based upon your intention to use the mark. And remember, you will not get a registration until you are actually using the mark. Now, you have a set time limit, right? And it expires. And we can renew, I think, for a maximum of 3 years. But every 6 months, I'm going to be harassing you. Hey, are you using the mark? No, I'm not. Are you using the mark? No, I'm not. And I've actually had clients that are like, after the 3rd year, they're not using the mark. Guess what? We cannot extend it anymore. Now you have to file again. Okay. Explanation. Initial review of both, which is where I was telling you, if you intend to use a mark, let's get the ball rolling, because the initial review will be of both the the use base and the intent to use applications. The United States Patent and Trademark Examiner will review everything to make sure that it complies with statutory requirements, very important, and to determine if there are any grounds for rejecting the mark. That's what we want to know. What does the USPTO attorney think? Will they allow it to register and continue, or will they issue a notice of allowance? If they issue a notice of allowance, it means that they're going to allow it to continue because you're saying that you're going to use it. If they don't, then now we know we have issues. So what happens? What is a rejection, right? So if the United States Patent and Trademark Office issues an office action, the applicant may respond, usually through an attorney. Yes, hire an attorney. It doesn't have to be me. I would love it to be me, but don't just respond by yourself. Hire an attorney. With arguments as to why the mark is registrable. A response is due within 6 months of the office action, so be really careful with that. If the response is unsuccessful, the rejection is generally deemed to be a final in a second office action. It is possible to file a request for reconsideration within 6 months and or an appeal, okay? So definitely let's look at that. If you received any office action, send them our way, we could review it, tell you what we think, and give you an estimate of cost to respond. So let's say that we're on the good side of things, right? So now, you file your trademark, the United States Patent and Trademark Attorney examined it, and he or she said, great, no problem, I don't see a problem with it. Well, now the world has an option to say if they see a problem with it. So basically what happens is it gets published for opposition. So there is a special, newspaper that they have, it's called the Official Gazette of Trademarks, and there's gonna be a 30-day opposition period for interested parties, right? And it's subject to an extension of 120 days. From the publication date to say, hey, this trademark infringes with us for some reason. If it's opposed, then there's going to be an opposition proceeding in the Trademark Trial and Appeals Board, which is the TTAB, and they will determine who has the right to register the trademark. I have never, in all my years of experience, which as of 2023, it's going to be 13, have seen an opposition. Thank God. So hopefully it won't happen to any of my future clients. But it could happen, of course. Yeah, I'm not saying it doesn't happen, but it hasn't happened to me yet. And I don't want it to happen. So hopefully if it gets published and 30-day opposition period happens after that, we should be able to get your mark. Yay. If, the effects of the successful passing through the publication stage, basically you're going to get a certificate of trademark. Before we used to get the physical certificate, now it's an online certificate. If it's a use-based application, you get a certificate. If it's an intent to use, right, we're saying we're going to use the mark, we're not using it yet, then we will not get a certificate, we will get a notice of allowance. And then as soon as you're using it, please let us know so that we can allege use. The notice of allowance, it's going to be issued for intent to use application where no amendment to alleged use has been filed, right? So we haven't said we're using it. We have to file the amendment to say we're actually using it, show proof that you're using it for them to be able to give us a registration. Let's see, I think I have another question. What is the process to protect software code intellectual protection? I've been told it's hard to enforce. What are your thoughts on software code trademarking or patenting? You can trademark the name of your software, and I would do that, right? You can trademark the name of your software, whatever name you came up with for your software, you can trademark. The code itself, now I'm not a registered patent attorney. However, I work with one, and he actually teaches at the FIU College of Law Patent and Trademark Clinic. He's fabulous. His name is David Barman. And once he told me that you can trademark something, register for a patent, something that you cannot typically do with a pencil, whatever that means. So my advice is reach out and I'll put you in contact with him. He is a patent lawyer. He's the best one. I send them, all of my clients, and he will tell you whether your software code is something to protect or not. It's something that you can get, I guess, patent registration or not. Bomboon, I think your name is, please reach out to me and I'll put you in contact with him. Thank you. All right. Requirement again, that we're going to talk about renewal. We want to renew applications with a declaration of continuing use. It's not enough that you got your trademark register. You have to continue to use it. If you don't use it, somebody can fight you and say, yeah, they have that trademark register, but they're not using it. And then you have to file this after 10 years. Again, there's going to be a filing fee for United States Patent and Trademark Office. We want to prove that we're still using it. You will have sometimes a grace period, but don't rely on that. And also, we want to do this, after 10 years, we want to show that we have been using the trademark, that we continue to use the trademark so that we can get in contestability. Dealing with trademark examiners. So, I can tell you honestly, the trademark examiner attorneys are very nice and they're actually really good at their job. And I love working with them. But also remember, they have access to everything, and usually they're being assigned per class. So they're really knowledgeable about their stuff. And sometimes they go above and beyond protecting. So we have to come back to them and say, no, this is how it should be. So sometimes they come back and they say that identification is unclear and needs to be clarified. So what we do, this is a simple one. We just try to identify the product or service. We file an amendment. We point out, what we think should be changed, and then that's it. You could also email this email that I'm putting there to get, acceptable identifications, or you can hire us to do it. So no problem at all. We always work with them. It's a continued communication. It's called trademark prosecution. I know it sounds scary, but it's basically a continued communication with the United States Patent and Trademark Office to see, can this mark be registered? And of course, we're always saying that it can, because it's in our interest, and we work with them to make it happen. If they come back and say that there is a likelihood of confusion, sometimes we can narrow the identification of goods and services to distinguish the marks. Of course, we will use all of the DuPont factors that I mentioned before to argue that they should register a mark. We also want to argue that consumers are sophisticated, and we want to put together a good office action response so that your mark can be registered. Okay, so let's say that you already got your mark registered for a product. What can you do now to really protect it? Well, imports of goods marked with infringing trademarks can be barred by the United States Customs and Border Protection. Under the Lanham Act, right, no article of imported merchandise should be admitted to entry at any U.S. Customs house if it copies or simulates a trademark register in the United States, copies or simulates the name of any domestic manufacturing or foreign manufacturer that treaty, convention, or law affords similar privileges to citizens of the United States, bears a name or mark calculated to induce the public to believe that the article is manufactured in the U.S. or that is manufactured in any foreign country other than the country in which is in fact manufactured. So if any of these things are seen, but the United States Customs and Border Protection, they are supposed to stop the product from coming in, right? So let's focus on copies or simulates a trademark register in the United States. So how do you get them to stop them? Well, here's the link. Once you have the registered trademark, you need to go there and file online so that they know that you have a registered trademark. You need to include your name, address, citizenship of the trademark owner, name, address of foreign persons or businesses authorized or licensed to use a trademark, because you don't want them to stop people that you actually have authorized to bring in those products. And you want to include your copy of the U.S. registration. And of course, they have a filing fee for each class of goods and services that you want to protect. In practical life, right, in real life, additional efforts are always required beyond simply recording the mark, right? So you want to keep on contacting them. You want to be on the lookout. Oh, that company's been bringing my products, copying them. So you want to let them know, right? So typically the trademark owners will likely see higher success rate in seizures of infringing merchandise if they continuously provide customs with such helpful information as the identity of the known foreign counterfeiters, their countries of origin, suspected importers, and the ports through which the merchandise is imported. So register your trademark, of course, first step. Second, register it with the United States Customs and Border Protection so that they know. And lastly, keep on giving them information. You want to make sure to do that so that they stop them. Here's the link so that you know where to do it. And of course, we will help you with that if you need, absolutely. And protect your trademark. All right, that's it, I think, for my slides. So let me stop sharing my screen here. So I don't see any more questions. Again, my name is Romy Jurado. I'm an attorney here in Florida. Trademarks is federal law, so we're able to help you wherever you sell your products or services in the United States. We will file your federal trademark registration. If you're in Florida, we also help business owners with contracts, leases, registering companies, buying and selling businesses. We do all of the legal due diligence, all of that. And we also help with immigration litigation, probate, estate planning, and real estate, of course. And now also accounting services, not through me, but through my husband's accounting firm, we will be able to provide that. He's a certified public accountant in Florida. So if there's anything else that you need, please reach out to us. If it's something that we don't do, I can put you in contact with an attorney or a professional that can assist you with a particular issue you're facing. I want to thank you so much for joining me today. I know that your time is very valuable and I appreciate it. I will send everybody a follow-up email possibly next week with the presentation and some further information. Thank you so much. I really appreciate it. Take care. Bye-bye.